provided the prosecuting agency with information for the prosecuting agency's Rule 15.1 database. With that, I'd be happy to answer any questions.
Okay, you know what? I'm going to hold this bill for now. I don't see the sponsor yet. I see Senator Majority Leaders here, so we'll go ahead and hear his bill next. That would be House Bill 27-123.
Mr. Chair and members, the rules of civil procedure for the Superior Courts of Arizona outline the methods by which cases that come before the courts are assigned to judges. In Maricopa County specifically, the assignment of cases may be done by automated means or a formula approved by the Supreme Court in order to facilitate an equal distribution of cases. These rules also outline circumstances in which cases may be reassigned to different judges. House Bill 2723 requires that the assignment of civil trial cases to judges be done by automated means or a Supreme Court approved formula, and the bill prohibits a Superior Court judge from selecting or refusing to accept an assigned case unless extraordinary circumstances exist. I have to answer any questions.
Any questions? Sponsor the bill. Majority Leader, welcome to the Judiciary Committee.
Thank you, Senator. Thank you, Mr. Chairman, members, for hearing the bill. I know today's long already, so I'll keep my comments very brief. I've been working with the courts to codify this process to ensure that the cases are randomly assigned. There was a amendment required in the House that we did, again, working with the courts. There are a few special benches, water law, and some complex cases, as an example, that we put in there. But the idea here is to make sure that we codify that all these cases that go through the normal process are assigned randomly within counties that have more than one judge, so that we don't end up having either the perception of or the actuality of any sort of favoritism in assignments. So with that, I'm happy to try and answer any questions.
Members, any questions? Senator Leach.
Thank you, and thank you, Mr. Toma, for bringing this forward. In your study and preparation for presenting this bill, what keys, what go and say, hey, this may not be random or may not look like it's random. Please share with the committee how we've got to this.
Thank you, Mr. Chairman. Senator Leach, there, right, wrong, or indifferent, that there has been the perception out there that certain cases end up with certain benches, and more perhaps disproportionately. The courts, on the other, have maintained that is not the case, with certain exceptions, as I've said before, specialty benches. And so this is a way for us to ensure that this process is formalized, that it happens according to state law, and that it can't be tinkered with on the back end. So it's a preventative measure largely that the courts have supported.
Mr. Chairman, Mr. Toma, when you refer to special benches, it's my understanding that only certain judges want to be in a pool for certain cases. Is that what you refer to as a special bench, or is that something different?
Mr. Chairman, Senator Leach, it is something different. The special benches are outlined already, as I guess, and I'm not an attorney, so you have to forgive me for not knowing the intricacies of the court and how it works. But the special benches that I'm aware of, I believe there are only two. One is complex cases, possibly three. They did explain that there is a specific judge assigned to tax cases that tax law, but it's in tax court, not necessarily with tax related, but just that are very specific types of legislation. And also water. There are certain water education. There's a water education bench because that's a highly specialized part of law. But most other cases, including most election cases, would be randomly assigned to all available judges, which would be, I believe, 16 at any given time. The only other exception is there are, at least within Maricopa County, I understand there are a couple of regional cases. There's a Northeast Valley Court, and there are only two judges there. But the way the court assigns those is based on the zip code of the attorney that's filing. And my understanding is that most attorneys are not up there. They're down closer to the Capitol, and so the vast majority of cases would be assigned to this new process, assuming this passes.
Mr. Chairman, Mr. Toma, in preparation of hearing this bill, I've been led to believe by people I've contacted that only certain judges want to be on election cases because it's typically very fast-paced, very pressure-packed. Is that what you found in preparing, Mr. Tom?
Mr. Chairman, Senator Leach, yes, that has come up, or that narrative has come up when it comes to election cases in particular, which is another reason that this is the right thing to do, to ensure that that is eliminated and that is not there would remain no sort of self-filtering mechanism for judges to avoid those types of cases in the future.
Thank you, Mr. Chairman. Thank you,
Any
Mr.
further questions? Okay, thank you for your testimony. All right, there's nobody signed in to speak. Leanna Garcia, if necessary, members, did you want to hear from her? Any questions for her? Okay, very good, Madam Vice Chairman. Bill?
I move House Bill 2723 with a due pass recommendation.
You've heard that motion, members. Secretary, please call the roll.
Senator Bartow? Senator Rowley?
Aye.
Senator Contreras?
Aye.
Senator Lee?
Aye.
Senator Gonzalez? Senator Palmer?
Aye.
Senator Rogers?
Aye.
Senator Peterson?
Aye.
6 ayes, 0 nays, 2 not voting.
6 ayes, 0 nays, 2 not voting. Given House Bill 2723 to pass recommendation.
Thank you, Mr. Chairman, Senators.
Okay, I'm going to go to 2347, please. Oh, Visucci's here. I'm sorry. Who did Visucci go? Where is he? Ah, he's too close. I can't see that close, and my reader's on. Go ahead.
Mr. Chair and members, House Bill 2696 increases the term of imprisonment required for a person who is convicted of an initial or subsequent dangerous crime against children in the first degree involving continuous sexual abuse of a child. The bill also outlines various offenses related to human smuggling and trafficking and are not eligible for suspension of sentence, probation, pardon, or release from confinement. Furthermore, the bill modifies the elements of an offense involving participating in a human smuggling organization or operation and increases the classification for violations of intentionally engaging in smuggling human beings and participating in a human smuggling organization. With that, I would be happy to answer any questions.
Members, any questions? Sponsor the bill.
Thank you, Mr. Chairman. Thank you, members. This bill is something we've been working on with the governor's office in regards to human smuggling. I think we've all come to realize over the last year or two that has been on the uptick, and we needed to really put the hammer down to make sure that people who are involved in human smuggling are actually going to prison for a long time. I think right now that the offenses or the sentencing and is not high enough, and so we want to make sure it's at a point to where they're going to resist from doing this in the future. This also includes some sexual child sex crimes that were missed in my bill from last year, and those are listed on page 5. And with that, I will be happy to answer any questions.
Members, any questions? Okay.
Thank you.
We don't have anybody signed in to speak. Public work necessary. As members want to call out of this up. Okay. Madam Vice Chairman. Bill?
I move House Bill 2696 with a due pass recommendation.
Without much, member secretary, please call the roll.
Senator Bartow? Senator Rowley?
Aye.
Senator Contreras?
No.
Senator Lee?
Aye.
Senator Gonzalez? Senator Palmer?
Mr. Chairman, may I explain?
Please do.
I think there's a couple of things going on in this bill, and I tend to get really frustrated when we take separate issues and conflate them together and put them in one bill. In this bill, there is language that talks about transporting, and it could possibly make it a crime who has an undocumented person in their car. Just driving somewhere, it makes this it turns us into a human smuggling operation. So if we're gonna talk about transporting and human smuggling, let's talk about that. If we wanna talk about child sex crimes, let's talk about that. But let's not shove these two issues in one bill for one vote. There are separate issues here, and I find it very hard to tease out the arguments and say all of this belongs in one bill together. I just cannot vote yes on this bill.
Senator Rogers?
Aye.
Senator Quezada?
Sure, Senator Lisa.
Thank you, Mr. Chairman. Yeah, I just want to echo the comments of my colleague here to my right. Yeah, the broadness of this bill is really, really troubling and scary. You know, these are family members that people are being transported, taking to school, taking to the doctor, visiting other family, taking to the park, and now we're being charged as human smugglers. It just doesn't make any sense to me. And my question again, like with the bill we heard just a few moments ago, is this making the anti-immigrant culture in our community better, or is it going to make it worse? Is this going to further divide our community, or is it going to bring us together more? Like, really think about that and ask yourself that when you are voting on this bill. I've thought about that a lot, and I'm looking at this bill, and it's a very easy answer for me, so I vote.
Senator Peterson?
I vote aye.
4 ayes, 3 nays, 1 non-voting.
Motion votes 4 ayes, 3 nays are not voting for House Bill 2696.
Thank you, Mr. Thank you.
Okay, getting to the sponsors here. Let's go to 2347.
Mr. Chair and members, House Bill 2347 allows an employer to extend a misconduct investigation against a law enforcement officer beyond 180 calendar days only if it is demonstrated that additional time is necessary to obtain and review evidence. The bill also allows an employer who is subject to a supervision by a court order monitor to extend an investigation by 360 days rather than 180 days, and requires an investigation that is not completed by the end of the extension period to be dismissed. It also requires, rather than allows, a hearing officer, administrative law judge, or appeals board to dismiss discipline if an employer does not make a good faith effort to complete the investigation within the 180-day time limit or any extension of time. With that, I'd be happy to answer any questions.
Members, any questions? Mr. Isaacson?
Mr. Chairman, good morning. Members of the committee, good morning. Don Isaacson on behalf of the Fraternal Order of Police in support of the bill. Justin Thornton, who is the executive director from the FOP, is also here. We're all familiar with when the power of government is turned against an individual, what that brings up is a concept of due process. Whether it's a criminal proceeding or whether it's the courts being used in civil litigation, due process is the right to be heard, the right to have notice, etc. One of the rights is that you have a right as the defendant in those situations, or the person being investigated, to have a conclusion. In criminal law, it's a speedy trial requirement. In civil law, it's a speedy trial requirement. A matter can't be initiated and then just sit there with a cloud over the defendant. In police, you, the legislature, passed a law several years ago, a number of years ago, saying if there's an investigation against an officer, it has to be completed within 180 days. Why? That's a huge cloud over a police officer, and for the community that's filed a complaint, possibly, they want resolution. But for the officer, they're frozen in place. What has happened is, although you set 180 days, it has become a toothless limit, and some agencies go well beyond that. One agency in particular recently is going as long as 3 or 4 or 5 years beyond that. Officer is frozen, can't go anywhere. This sets an additional time limit of 180 days, so it's 180 plus 180. For a federal agent, for a law enforcement agency under federal supervision, it's 180 plus 360. It's a full year and a half.
Burton, second.
I'd be glad to answer.
Any questions? Yeah. So,
Thank you, Mr. Chairman. Hey, John, so these investigations that are going longer than 180 days, is there like stats on like what the end result of those investigations are, even the ones that are going beyond what I guess the basis of the question is, like, is there legitimacy to these investigations? And so is it necessary for them to be going that long?
Mr. Chairman, Senator Quezada, great question, and I think it's situational with each agency. In the case of the one agency, which is MCSO, which testified against this bill in the House, it is an administrative workload issue. It's not a complexity of the case. They have a lot of cases, and if you're in the poor position of being on the bottoms of a stack, where they don't get down to you, it may be a relatively simple matter to investigate, but they may not even get to that matter till 3 years later to get to it. I want to read, if it's okay, I'd like to read a point from the Federal Monitor, which I think addresses the issue. This is from the latest Federal Monitor report. Workload-based extension requests have led to an untenable situation of investigations being prolonged indefinitely as long as they comply with an administrative requirement. There is simply no justification for community members and MCSO employees to wait an average of more than 16 months for complaint resolution. The bill before you gives more than 16 months for them. For a normal agency not under federal supervision, it's 360 plus, it's 180 plus 180. No one has said that's not enough time. No city police agency, not the chiefs of police, not even the sheriff's offices that aren't under investigation. So if it's under federal supervision, they get 180 plus 360, a full year and a half. The Federal Monitor has told Maricopa County to complete investigations within 85 days. What this says is your 16 months is beyond justification. And in some cases, we're aware where the investigation has gone 4 years. For an officer to be under the cloud, can't go sideways, can't go to another agency, can't go to a private employer. And the saving grace of this bill is if it's dismissed and more evidence comes in, it can be opened again. It's not forever. It's not res judicata. It's not closed forever. So if that officer is in fact a bad officer and more evidence comes in that wasn't available on the first review, the investigation can be initiated again.
Mr. Chairman,
Yeah.
quick follow-up. Thank you, Mr. John. Regarding that reopening, is it only if new evidence comes in, or like you said, here's my concern. If it's like a workload issue, right, and they just don't have the people to go through all these investigations, which I get, that's a problem. And it's not fair to the officers, not fair to the public either, if we file it. But if there is like a legitimate complaint at the bottom of that pile, like there's legitimate issues there, and it comes to that 180-day deadline, and they get the renewal, are they able to reopen it again without the new evidence, but then they finally get to that file and look at it and see, okay, this is a legitimate issue?
To that point, Mr. Chairman, to that point, why should the officers suffer because a department has not figured out how to take care of the cases at hand? Why should the officer be forced to be under the umbrella that Mr. Eisenstein has talked about? That should be adjudicated and taken care of.
Let's let Senator Quezada finish his question.
That was my question. Thank you, Mr. Chairman.
Mr. Chairman, Senator Quezada, the way this is structured is the original 180-day limit has been there a long time, but over time it has been less of a limit. And so this says you get 180 days. If you need time to get more evidence or to review the evidence you have, you can go another 180. So there's already an automatic built-in extension for those circumstances. If at the end of a full year, you haven't moved, then it is dismissed.
it can again be opened up, and it's on page 1, lines 25 through 29. This is after a full year of investigation and then it being closed. The time limitation set forth in A does not preclude the employer from initiating a new investigation of the employee for misconduct upon newly discovered material evidence that could not with reasonable diligence have been discovered during the initial 180 calendar day limitation or any extension. So it does, if there is truly a bad officer, and there's been some reluctant witness to come forward or whatever, or late developing evidence, it can be reopened. But this defers to 180 days and then 180 days. With your permission, I want to mention some reference points. The International Chiefs of Police says investigations should be completed within 45 days. When I met with Mr. Blackman in the House, who spent his career in the U.S. Army, he said the U.S. Army establishes a limit of investigation of 45 days. DPS, our state's primary police organization, follows 180 days, and they have a good faith extension or just cause, probable cause investigation for it. They can extend another 90 days. So it's 180 plus 90, but then it's it. And there's nothing about reopening at that point. It is. So everybody lives within this one system, and all of the city police agencies have said they could live with it. My understanding is the counties can, in fact, Maricopa has said, we could if we weren't under federal investigation. So I don't think there's a problem with the 180 plus 180. The issue is, what do you do with an agency that's under federal supervision, and this gives them a full year plus the 180. The officer, in the meantime, is frozen, and part of the system has to be to ferret out bad officers, but part of it has to be fairness to the officers as well.
Okay, any further questions? Yes, in the row.
Yes, Mr. Chairman, and Mr. Isaacson, and while the officers, is he on paid leave, is he on working desk, what happens to that officer?
Mr. Chairman, Senator Borelli, I think if there's a variety of circumstances. We're aware of a case in Maricopa where an officer had a complaint, was put on leave. He was paid $156,000 for sitting by his phone for almost 3 years. Meanwhile, they had to backfill his position. I think it varies situation to situation, organization to organization.
Thank you.
All right, thank you for your testimony. Marie?
Thank you.
Okay. Bell? And then to Ms. Barlow.
Good morning, Mr. Chairman, members of the committee. I promise this is the last time today. My name is Kay Bell. I'm here on behalf of the ACLU of Arizona. I agree with the prior witnesses that it is outrageous that it has taken this long to complete these investigations. The court order against MCSO requires it to be completed within 85 days, and yet it was 499 days in 2019 and 552 days in 2020. That is outrageous, regardless of whether you're the officer wrongfully accused or you're the community member who is waiting for justice because you have been wrong. But the issue with this bill is that what happens when this limit is exceeded is it's just dismissed. And the court order in that case, and I'm going to quote directly from it, cites a policy that, quote, provides that the appeals board may dismiss discipline if it determines that the MCSO did not make a good faith effort to complete the investigation within 180 calendar days. And then the court, and I again quote, found, in the past, MCSO purposefully exceeded this time limit to justify imposing no discipline or only minor discipline, end quote. So you have situations where there may be a legitimate complaint at the bottom of the stack, and then the agency purposely slow walks the investigation, knowing that if they exceed that time limit, it will be dismissed. The solution to this problem of the officer and the public having to wait an outrageously long time is to, if the agency can't do it, appoint an independent monitor to do it for them. And with that, I respectfully request that you vote no on this bill.
Thank you for your testimony. Any questions?
Yeah, Mr. Jeff, thank you. Is there, and it's probably just you may not have this information, but I am just curious why these investigations are happening in the first place. Why? Yeah. Why?
Let's go.
Yes, thank you, Mr. Chairman. So the underlying case that we keep referring to with this federal court order is called Melendrez versus Penzone now. It's actually an ACLU of Arizona case against the MCSO for violating the constitutional rights of the citizens of Maricopa County. That case was settled. It's now been years ago. The MCSO obviously just chose to settle that case and enter into this court order. And one of the things that they agreed to when they settled this case was that they would complete these investigations within 85 days. And these are complaints from members of the public that their constitutional rights have been violated, that they are bringing to the police department. So they're not criminal cases, they are complaints made by your constituents.
Any further questions? All right.
Thank you.
Mrs. Farley. Got a minute and a half, sir?
Good morning, Mr. Chair and members of the committee. My name is Timothy Sparling. I am a lawyer and legislative advocate with the Arizona Attorneys for Criminal Justice. AACJ does oppose this bill. I believe that we were sympathetic to the argument of we don't want to have this, all over an officer's head forever. But our main concern is the remedy here. This basically provides officers who have committed misconduct a legal pathway to get away with their misconduct. That's what this does. On top of that, it gives unfairly unfavorable treatment to officers over just normal people in the community. For example, if you're facing a crime or a misdemeanor offense and your constitutional rights are in jeopardy, you only have 365 days. You get 365 days before the statute of limitations runs. This gives officers 360. So an officer who doesn't have a constitutional right to be an officer only has 360 days before the case goes away. But if your rights are jeopardized and you're facing a misdemeanor offense, you have 365 days. So this is giving officers some unfair preferential treatment here. This also doesn't really fix the problems. If the problem is the efficiency of the IA process,
30 seconds.
the fix to that isn't letting officers who committed misconduct go. The fix is let's reevaluate the process. Let's think of better resources. Let's think how can we restructure this to make it work. Not this officer has committed misconduct. Oh, they've now drugged their heels during the investigation process. Now they get away with it. That's not a fix.
Final thoughts.
And with that, AACJ does oppose this bill, and I'm happy to stand for questions.
Any questions? All right. Thank you, testimony.
Thank you.
Mr. Isaacson, we've got some questions for you. Could you address this, the concern that if they can slow the clock, just run out the clock?
Mr. Chairman, members of the committee, one of the exceptions that continues on for the ticking clock is the waiver by the officer. So if the officer says, I need more time, I waive the right to have this completed within the time, that stops it. They can't be dilatory and delay and still have the benefit of it. This is parallel to what goes on in civil trials, what goes on in criminal trials. And it puts a burden on the agency or the plaintiff in a civil trial to get your case together, because that person, you have named that person, you put them under a cloud as either a civil defendant or criminal defendant. It's on you to get your case to move forward. And so whoever brought the investigation, it's on them to be completed. I give DPS as an example because you probably haven't heard any concerns about DPS because it works. It is 180 and then it's another 90 as a pressure valve with the same exceptions. If somebody waives the right and says, I want more time, that stops the process, the ticking clock, and they can't benefit from that. But all other situations where there is a plaintiff and a defendant or a prosecutor and a defendant, there is a time frame, and if the person who brought that case forward doesn't complete it, it does end. The saving grace here is the officer can be investigated again, but if the agency has a set of facts for 360 days and they don't act on it, and there's no new facts come in, it is dismissed. That is the only fair result for that officer who's under the cloud. I have not heard from a single agency other than MCSO that they can't get the work done on a basic complaint against an officer within that time frame. The only issue came up with the federal mandate with Maricopa County and their workload issue. It's not a complexity issue, it's a workload issue. They've got a lot of cases, and the federal monitor has said to Maricopa County, hire 10 people. And at the end of the period that was under review, Maricopa had hired 1. They simply have not hired enough people to process the complaints that exist there. And everyone else goes home on time with their paycheck, with vacation, with bonuses, whatever else they get. The person who suffers is the officer and their family, who remains under the cloud for a year, 2 years, 3 years. You heard someone testify 500 days. That's an incredibly long time period to be branded under investigation. In fact, I would add this. Maricopa said that the bigger cases rise to the top and they get those done. It's the less serious ones that get pushed to the bottom. And so if you're a less serious violation, sleeping in your car on your midnight shift, and you're at the bottom or treating a citizen with poorly, you get pushed down and you're the one who is under investigation for 3 years or longer.
Other questions for Mr. Isaacson? Okay.
Thank you.
All right, anybody else wishing to speak? Oh, okay. We don't have you, but if you could come on up and then we'll have you fill out.
Mr. Chairman, members of the District Committee, my name is Justin Ford. I'm the Executive Director of the Arizona FOP. Quite a bit of testimony today on this, so I won't take up too much of your time. But like Mr. Isaacson said, this statute was put in place with the intent of finalizing these investigations after 180 days. I actually agree with the lady from the ACLU that these investigations need to be done. This is our attempt to put teeth into that 180-day, the original 180-day statute, and to force the departments to get these investigations done, not only for the officers, but for the community members as well. The investigations that are taking this amount of time, this extraordinary amount of time, are not complex. We've heard that time and time again. These can be anything from an internal complaint about one employee against another. It could be a citizen saying that an officer was rude or an officer ran a stop sign. They're not investigations that warrant any amount of time that even justifies the length of time that these investigations take. Just final thought. Nobody wants bad officers off the street as much as good cops do. And there are specific areas of this statute and the statute that was there before that expressly prohibit the investigations being dismissed for no reason when there's obvious reasons that it has to continue. Those include criminal investigations and investigations where the officer and the public may not be available. So we ask that you vote in favor of this.
Thank you. Any questions? Madam Vice Chair, please move the date.
I move House Bill 2340 with a due pass recommendation.
No.
I move House Bill 2347 with a due pass recommendation.
For that motion, members, Secretary, please call the roll.
Senator Barfield. Mr. Chairman, just to explain my vote.
Yes, please.
Mr. Chairman, sounds so much like what we're dealing with a lot of the health licensing boards. And in fact, we have a bill moving forward to address that same thing. Licensees shouldn't be dragged along while they're under investigation simply because, they have a lesser charge against them or a complaint against them. Can be just a workload issue.
So we're trying to address that in a separate bill, and I completely understand why we need to do this for the sake of the officers, and I vote yes.
Senator Rowland?
Aye.
Senator Shirley?
No.
Senator Lee?
Mr. Chairman,
Yes, sir.
I'm in full support of this and will be voting yes. Senator Barlow spoke of the licensing in the healthcare field that she spent so much time in study and diligence. And I'm also running two bills, both of which have gone through here, where we have members, lawyers that are being held at bay under the Drug Bar complaint. And I'm proud to report that one of two bills came out of House yesterday, and it seems to be it's a growing infestation within government to think that they can just roll over the people that are serving in that capacity. That I will not.
Senator Gonzalez?
Mr. Chair, it's been a vote.
Yeah.
I think Senator Mr. Levitt just convinced me out of vote, because I remember that bill, and I am an attorney, and I'm licensed to the state bar, and I'm subject to those complaints. I'm subject to that investigatory process, and some of those complaints are simply nonsense. And I'll be honest, I've been subject to a couple of those complaints. So I've had to sit through those investigations and go through that process. I didn't like it, not one bit. But I also know that as an attorney, that process is there for a reason, and that process is there to keep out the bad attorneys, and it's there for those complaints that are legitimate. And so even though I have to suffer through some of those illegitimate complaints, I'm happy to do it, because I know that it protects the profession, and it keeps those bad apples, those attorneys that are doing really bad things with clients' money, with their clients' freedoms, with their clients' legal issues. It's keeping them at bay and it's holding them accountable. So it's a part of the job that I'm willing to accept. And I believe that as unfortunate as I know that it's not fun for these officers that are subject to these investigations. They don't like it, and not one bit. And if it keeps them locked into one job or one position, that's not very fun either. And I sympathize with that. I do. I think that there are ways we could speed up those investigations, because that absolutely should happen. The officers who are accused deserve that. But the public deserves that if they have a legitimate complaint, they deserve that complaint get fully investigated as well. And they also deserve that if an officer does wrong, that he or she be held accountable. And I think that this leaves a small window, it may be a small window where a bad acting officer is able to get away with something because either the department slowed off an investigation or the clock just simply ran out and no new evidence was found. And it allows that one bad apple to get by. And I think that's one too many. And so with that, I vote.
Senator Paul Henderson?
No.
Senator Rogers?
Aye.
Senator Peterson?
Our founding fathers were so wise that so many good principles that they put in place for us. One of those is a speedy trial. And we can imagine why that is. There were some great points brought up about, running out the clock, but I don't think those are valid. Those are, people need to run things properly, and that's within their power, they can do it. So with that, I vote aye.
5 ayes, 3 nays, 0 non-votes.
No, everybody votes with 5 ayes, 3 nays, 0 not voting. You've given House Bill 2347 be passed for recommendation. Okay, let's do 2378.
Mr. Chair and members, House Bill 2378 prohibits the Secretary of State from settling an election-related civil action that materially affects a county recorder or elections officer without consulting the affected county recorder or elections officer. The bill also prohibits, if the evidence provided is sufficient, the Secretary of State from entering into a settlement without the approval from the county recorder or election officer. The bill also allows a county recorder or elections officer to join as a party in an election-related civil action as prescribed. With that, I'd be happy to answer any questions.
Members, any questions? Okay, I don't see the response to the bill here, but this is somewhat similar to unless there are a couple of actors that come in and prove that. So with that, let's go ahead and hear some of the testimony. We've got Jody Leggett here. Cassandra, who's still around. Okay. Jen. Always count on Jen. Well, I see that you're signed. I would like for you to come up since the sponsor's not here. It says you're signed in support. Share why that's where you are.
Mr. Chairman, members, Jennifer Marson with the Association of Counties. Mr. Burley, I would like to draw your attention that I am signed in support. Thank you.
Every once in a while.
Every once in a while. Well, yes, so we have found ourselves in some situations before where the Secretary of State's office has made some decisions that the counties weren't aware of were happening, and so we just want to be at the table so that we understand if we're going to be bound to do something, that we are party to that conversation before it is finalized. Happy to answer any questions.
Thank you, Mr. Chairman. Jen, doesn't this go a little bit beyond just giving you a seat at that table? Because I agree, I think, the Secretary of State should be consulting with county reporters on these issues, but doesn't it kind of give them a veto power, or just one county reporter a veto power?
So, Mr. Chairman, Senator Quesada, I don't have the language in front of me, I'm sorry. Someone else has mentioned that to me as well. I think maybe I can see where that sentence could be read that way, but I also can see where it's not. And so I haven't had any pushback from my membership. My clear direction is to support the bill, and so that's kind of where I'm at right now.
Okay.
And Mr. Chair, Jen, I think I would be okay with the bill if that's the direction we're going, where it was like a consultation that was required, which I'm okay with. But if it did allow just that one kind of legal talk for one county reporter, then I don't think I'm good with it. So if there's like clarifying language you might want to offer,
Okay, so Mr. Chair, Senator Quesada, I see your point, but I guess my question would be, I understand we wouldn't want any one rogue whatever to hold up the suit or the decision, or, but the consultation alone puts us in the same position sort of that we are now, right? Yeah, we had a talk, but I'm just gonna do what you don't want me to do. So there has to be some sort of mechanism that allows the entity that's going to administer the results of this decision on the ground to be an active part of that decision-making process.
and Mr. Chair, Jen, and that's why I think like if it was like a consensus of the county recorders, like something like that, so it's not just one.
Okay.
Like, yeah, I think a consensus is fair.
Mr. Chairman, Mr. Quesada, I'm happy to talk to the sponsor, see if we can finesse that language a little bit.
Thank you for your testimony. Members, any further questions? Okay. There's nobody else signing to speak. Vice Chair, Bill.
I move House Bill 2378 with a due pass recommendation.
That motion, members, Secretary, please call the roll.
Senator Barca? Aye. Senator Burley?
Aye.
Senator Contreras?
No.
Senator Lee?
Aye.
Senator Gonzalez?
No.
Senator Swan Hamilton?
No.
Senator Rogers?
Aye.
Senator Peterson?
Aye.
5 ayes, 3 nays, and 1 nay.
Everybody votes with 5 ayes, 3 nays, 0 voting. You've given House Bill 2378 passed recommendation. Let's do 2695.
Mr. Chair and members, House Bill 2695 allows the court, after a person is convicted of an offense for which forfeiture applies, to order the forfeiture of substitute assets that have up to the same value as property or other interest that is either acquired through criminal enterprise or traceable to racketeering offenses. Additionally, the bill states that statute does not prevent the state from returning any property to the owner of said property or prevent the filing of a racketeering lien or a restitution lien. Happy to answer questions.
Members, any questions for that? Thank you, sir. It's my experience bill. As you recall, we had the civil asset forfeiture bill last session. I remember, I think that was bipartisan all the way through. I think that passed out both sides unanimously. This is cleanup for that. Everybody's on board. There's no opposition. In fact, this bill is so exciting, nobody is signing to speak, and nobody is signing against. Right? There you go. So with that, members, unless you have any further questions for staff, we're going to go ahead and move the vote. Okay, my Vice Chair.
I
move House Bill 2695 with a due pass recommendation.
Heard that motion, members, Secretary, please call the roll.
Senator Bartlett?
Aye.
Senator Rowley?
Aye.
Senator Jerry? Senator Leach?
Aye.
Senator Bella?
Aye.
Senator Swan Middleton?
Aye.
Senator Rogers?
Aye.
Senator Peterson?
Aye.
8 ayes, 0 nays, 0 non-voting.
Members, by your votes of 8 ayes, 0 nays, 0 not voting, even House Bill 2695 is passed for elimination. We're going back full, Bill 2340, and that concludes our calendar. Have a nice lunch, everybody. Judiciary Committee is adjourned.
Thank you for being with us. This is MAAP Talk Show. We shall return.